statistic I saw is that Wisconsin per capita has the third highest number of local government entities having regulatory jurisdiction on any particular topic. So that means in Wisconsin, we love local government. We have a real desire. It's innate in us to be controlled or to be regulated at the local level, to have a connection between the people and the government that regulates them. So when we talk about zoning fundamentals and we talk about this concept of what's called Euclidean zoning or comprehensive zoning, we want some sort of plan for the orderly development of properties, both in their character and their use. And so we get into conflict when we have differing views at the county level, the city level, the village level, the town level about the character and utilization of property. And when we get into those conflicts, that's what we see with things like Act 264. We have a particular locality that is saying, you know what? I don't want that use in my backyard. And county, you're saying it's okay. I'm saying it's not okay. Therefore, I'm going to pull out of county zoning and make sure that we have the ability to say no, even though county's going to say yes. That's a very simplistic view of Act 264, but realistically, that's what we're talking about. And Rebecca and I have constant communications with counties out there in dealing with towns, especially as it relates to the overlap issues on zoning and land use. Shoreland, floodplain, things of that nature. Whereas counties, we have a specific role within the law, within the statutes to regulate in a particular area. And towns also have concurrent regulatory authority, but it's not the same regulatory authority. So where do we draw those dividing lines? And again, how do we, from a zoning fundamental standpoint, make sure we satisfy all of the requirements and meet all of the requirements of these fundamental propositions of it's a plan. We have to have a plan in place for a particular area. It identifies these different districts and identifies permitted uses, identifies prohibited uses, and so on, regulates to advance public health, safety, and welfare. And what happens when we have conflict then between those overlapping jurisdictions that have regulatory authority? So again, when we look at county general zoning, 59.69 of the statutes, of course, provides counties with comprehensive zoning authority. That means that every unincorporated part of a county can be subject to a county zoning code. There are counties out there, obviously, that have no zoning whatsoever, and that's fine. That's allowed under the law. When I say that's fine, that doesn't mean it's a personal preference. That just means the law allows a county to say we're not going to have zoning in our county. In those counties, we have townships within those counties that have adopted general zoning codes. And so what you see, just if you look at a map of the different zoning regulations within the different areas, you've got a whole bunch of different colors that are represented on that map. And I'm trying to think, Rebecca, yeah, there it is, right on our cover page. Yep. All of those different shades of colors represent different zoning regulatory authority. City, village, county, town, and so on. So you see in Wisconsin that we've got a mix and match of different types of zoning regulations that are going to impact how owners of property are able to utilize their property. Let me pause there. Anything you wanted to add, Rebecca? I've been talking here for about 8 minutes and I haven't let you speak. I'm sorry.
Nope. You're way more fun to listen to than I am. So keep going.
So what are the town options? And this is where it gets a little bit complicated. Because again, in Wisconsin, we love local government. Okay, awesome. We think that representatives nearest to the people ought to make those decisions. Okay, that's great. But then when we talk about the potential conflict between county zoning authority and town zoning authority, this is where it gets a bit confusing. All right, so towns can opt into county zoning. Towns can simply say, hey, you know what? We want in the comprehensive zoning ordinance that the county has created under 59.69 of the statutes. There's a process for town opt-in under 59.69 sub 5C. Whenever a county undergoes a comprehensive revision of its zoning ordinance, its zoning code, the town has an additional opportunity to opt in. As we'll talk about in a moment, that circumstance also leads to an opportunity for a town to opt out. But again, upon creation of a code at the county level or a significant amendment of that code, comprehensive revision, town has the ability to opt in. The town can also adopt village powers pursuant to 60.62 of the statutes. If it adopts village powers, it gives rise of the ability of the town then to control its own zoning. as Rebecca notes on the slide here, it's a key point. The mere adoption of village powers is not an automatic opt-out from county zoning. And so we say all of this, and many of you are going to say, this is very fundamental, but you would not believe the number of questions we get about this process. So there is a distinct misunderstanding out there about how this process works. I think a lot of towns think, well, if I adopt village powers, I'm out of county zoning. Not so fast. That's not the way this works.
Andy, can I
And then
stop?
we have, go ahead, Rebecca.
Okay, if you can flip back to the last slide. One of the trends that we're seeing that I wanted to mention was the comprehensive revision option under 5969 5D. As many of you know, counties first developed their comprehensive zoning ordinances, 50s, 60s, 1970s, and a lot of towns at that point in time opted in. Well, a lot of those zoning codes may not have kept up with the sophistication that we see at the zoning level or at the level needed now. Some zoning codes out there are sort of a mishmash from the original codes of the 1960s and 70s, with more modern aspects like plan unit developments. So we're actually seeing more counties either considering or doing comprehensive revisions than at least I've ever seen before. And so this ability for a town to opt in or not opt in upon a comprehensive revision is becoming more of a thing than I've ever seen before. And the interesting part of this is if a county does a comprehensive revision, a town that is not happy with county zoning can use that as an opportunity not to opt in. And so that, again, just kind of a creature of the times, but that's a trend that we're seeing, in our office that we haven't seen before. So just wanted to put that out there as another, option that towns may have to, again, quote unquote, opt out by not opting in if counties are going to do a comprehensive revision.
Well, and I think that brings up a point, Rebecca, about process. And I want to highlight this because we've had the pleasure of working with a few counties on their process of going through their zoning code and determining whether they're going to do a comprehensive revision. The process is important because I hear counties say all the time, we need buy-in from the towns. Why do you need buy-in from the towns? Because we want to make sure that they stay under our zoning jurisdiction. Why do we want that? We want continuity from a planning perspective as it relates to land use within our county. And so a lot of the effort is not so much in just making sure that every I is dotted or T is crossed within the revised code. It's having conversations with towns and other impacted stakeholders to make sure that there's buy-in, that the revisions make sense. As Rebecca noted, a zoning code drafted in 1975 is going to look much different than a zoning code drafted in 2025. Maybe some might argue that's not all good, but it's going to look different, no doubt about it. I think it's incumbent on us as counties to be leaders out there in having those discussions with the towns. Again, not so much, well, I shouldn't say not solely because of this process that towns have to not opt back into county zoning, but as we'll discuss in a moment with Act 264, if a town withdraws, I don't think we've fully explored all of the impacts that could happen if a town withdraws from county zoning and it's not done properly. Again, we'll get into that in a bit, but part of the reason that we want to have those discussions and get that buy-in is so we don't ever have to face the Act 264 dilemma. So we've got these town opt-out procedures, and then we have exceptions to the exceptions to the exception. And that's what makes our life as lawyers eminently interesting, is that we've got in 2013 Act 287 that creates the Waukesha County exception as it relates to town zoning authority. All right. So again, there's a special provision dealing solely with the towns in Waukesha County. And as we go through what that Waukesha County exception is, the details aren't necessarily critical or important here. It's just to point out that there are special rules that apply in special areas of the state. So did you want to talk at all about the Waukesha County exception, Rebecca?
No, other than the point of the Waukesha County and what I call the Dane County exception are kind of stepping stones to how we got to Act 264. And again, as you mentioned before, it's important to understand how we got here because I think that is how we can address the issues that we have now that we have Act 264. And so again, Waukesha County exception being a really good example of how the legislature felt it necessary to make this carve out, for a particular county, which as a large county, I think Waukesha County still, I think, has 8 towns. And so, that again, for being a very populous county, that's a lot of towns. So legislature is aware of these issues. And again, a good example of how we got here, and we can use that as an example of how we move forward.
Well, and you mentioned the Dane County exception. The Dane County exception provided the blueprint for Act 264. Back in 2013, 2014, there became a movement within Dane County at the town level to say, look, we do not agree with the way that the Dane County Code is being administered. We don't want to go through the process under 62, what is it, 60.62 to withdraw. We want a simplified process to control our own land use decisions as Dane County towns. And so the Dane County Towns Association lobbied the legislature, convinced the legislature that they needed this Act 178 to create a special exception, the Dane County exception, allowing those towns in Dane County to withdraw from county-wide zoning. I think that if you speak with some folks in Dane County, I know that Rebecca and I have spoken with practitioners, lawyers that assisted Dane County towns. There were some struggles in trying to identify exactly how this process is going to work. And so I think we're going to, just like with the Dane County situation, we're going to learn a lot about Act 264 as the years go by. There are conditions and safeguards associated with town withdrawal from Dane County zoning that are baked into Act 178. Again, that provided the blueprint for Act 264, and we'll talk about some of that in just a little bit. But the lesson here is that I'm hoping that we have the ability to create a relationship with our towns so that we never utilize Act 264 or never utilize Act 178. That would be wonderful if we could accomplish that. Whether we can or not, that remains to be seen. And so again, I highlight this because I mentioned before that this was the blueprint for Act 264. So what are those safeguards that I just talked about? Well, number one, a town has to adopt a comp plan under 66-1001. All right, that's a requirement for the town. It has to have a zoning ordinance adopted under 60.62 and meet specific criteria that are identified in 6023-4C 1 through 4. And then they also have to have a map. So 3 very important elements for a Dane County town to withdraw from Dane County zoning. We are going to see the same type of requirements imposed upon towns in the context of Act 264.
Andy, can I
So,
jump in?
I'm sorry, go ahead, Rebecca.
Okay,
Interrupt
so
if you want, it's fine.
we're gonna, if you can flip back to the last slide, please. Again, we're talking blueprints, Act 178 being the blueprint for Act 264. And these safeguards, I feel like we need a big drum roll before we talk about the safeguards, because these safeguards really are kind of the key to consistent planning as we move into the realm of Act 264. And again, being a blueprint, my hope is that we can look to how the safeguards have played out in Dane County and any wrinkles that were experienced there. Maybe we can apply those lessons learned as we move forward with Act 264, because these safeguards, these are a big wrinkle.
All right, so let's talk about an overview of Act 264 and what it did. So again, we took the Dane County Act 187 language and said, okay, well, if it works for Dane County, and we can debate whether it works for Dane County, but if it works for Dane County, why don't we extend this opportunity to all towns in Wisconsin? All right, so that's what the legislature was looking at in extending that ability. All right, I want to make this clear that WCA was involved in the negotiation, so to speak, of the language in Act 264, but it was not a county-led effort. WCA certainly was not pushing for the expansion of the Dane County exception statewide. That's not the point. The point is that the towns came to WCA and said, we've got legislative support for this initiative. We'd like to work with you to try to reduce the potential harmful impacts of what happened in Dane County if we expand this right across the state. And so we had the opportunity as WCA to comment on the legislation, try to provide additional safeguards, try to provide clarity in areas that we thought there was ambiguity, but it was not a WCA effort, but it was, to the Towns Association credit, it was an effort on their part to try to accommodate some of the concerns that we had as counties. But I want to make it clear, because I've heard it out there that WCA was behind Act 264. Absolutely not. That was not a WCA-led effort. But WCA did have input into the drafting of the bill that ultimately became Act 264. So what is the goal of Act 264? Because I think for the most part, and I'm not going to say it's universal, but for the most part, towns and counties get along well. We often have overlap between town board and county board. There's a reason for that. The reason is because the people who are invested in town government are also invested in county government. If we look at the role of counties in the unincorporated areas within the county, they have a significant role when it comes to land use, when it comes to other regulatory authority. And so we have typically a good relationship between towns and counties. I said it's not universal. There are areas of disagreement between towns and counties. And so from a towns association perspective, what they were hoping to accomplish is, number one, satisfy some of their members who said, I no longer want county zoning. You got to give me the opportunity to opt out. And I think from the towns association perspective, they said, okay, but is there a way that we can maybe force some folks to the table to have a discussion about these issues before we just outright let you out of county zoning? All right. So the goal here is to foster communication and foster a cooperative relationship between towns and counties. And Rebecca put up my quote there, which I thank you, Rebecca, for doing that. I hope this statute's never used. I hope that Act 264 is a piece of legislation that nobody ever uses. And that ought to be our aspiration, is that nobody ever has the need. All right. I'm not talking about desire. I'm talking about the need to use Act 264. So that's the purpose and intent behind Act 264. So Rebecca, do you want to talk a little bit about what it does and what it means?
Yeah, absolutely. So obviously everybody can read. You can open up the statutes and read Act 264, but we felt it's really important just to copy the text here, because there are so many particular deadlines within the text of the new 60.23 sub 35, which is obviously Act 264. And as Andy mentioned, and Andy, jump in here, because since you were intimately involved in those discussions leading up to what became Act 264, one of the safeguards from the county's perspective that was very, very important were these timelines. And so when you look at the subsections of 2 years and then 2 years and then the effective date, we're talking like a 5-year time frame since the inception and the effective date of Act 264 in 2024. So a town may not withdraw from county zoning later than, or I'm sorry, no sooner than March 31 of 2029. And so again, you will see in the statute itself these very long timeframes for planning purposes and for the process for towns to have these discussions, obviously with the county. So again, the intent being fostering of communication and ironing out all of these issues that a town may have as it operates under county zoning. And so we've got a lot of time to have those communications. The other reason for these long time frames is because the town has a lot of planning to do. And so to really emphasize the importance of these safeguards, being the town comp plan, the town zoning ordinance, and the town official map, it's important that the town have enough time to implement those safeguards. And so now on this slide, we've got, just a bit of a more breakdown on those timeframes. The effective date of Act 264 was March 31 of 2024. So we're almost coming up on 12 months. But again, a town may withdraw no sooner than 5 years after the effective date. So no town in the state can withdraw before March 31 of 2029. So that gives us now even 4 years to have these discussions. So again, I just mentioned these briefly, but wanted to make sure we have all of these in front of you folks for for reference later, that it's no later than 2 years before enacting a zoning code, the town must adopt this resolution setting forth the town's intent to withdraw. And so that is then must be sent to the county clerk. And really that's kind of the trigger for these comprehensive discussions and this communication and fostering of cooperation between the towns and the county. And that's why, Andy, correct me if I'm wrong, but I think that's perhaps one of the reasons why WCA felt it important that there actually be official notice to the county clerk, so counties are aware of what towns' intentions are and what they're going to be doing.
Well, the other thing is that, I mean, what happens every 2 years and even numbered years?
New board.
What happens every other year in odd numbered years? We have town supervisors elected. So there will be turnover. And one of the things, at least from our perspective, is that if there's a desire to get out of county zoning, so to speak, we don't want it to be a whim, a 2-year issue that passes. We want there to be some continuous, longstanding issue or concern that we're going to address with town opting out that is going to survive board turnover at the county level, board turnover at the town level, and that there's that momentum to make that change. We wanted to make sure that happened. That's why you see these timeframes work out the way that they did, is so that we overlap these election periods to make sure that there's sufficient understanding of exactly what's going to happen if there's an opt-out on the part of the town and the county.
Mm-hmm.
All right, I see we have a question from John. If a county goes through a comprehensive zoning ordinance review, can the towns elect to withdraw once it's done before this timeline? If you go through, yes, towns have to approve. If there's a comprehensive revision to the zoning ordinance, towns have to approve that in order for it to be effective in the town. That's under 59.69 existing law, independent of Act 264. So if you go through a comprehensive revision to your zoning code, then the towns have the ability to say, no, it's not going to apply here.
Mm-hmm.
All right, so continue with the implementation timeline. And this is where we get into the conditions.
All right. So this is our big qualifier, the big importance of the safeguard. So on the last slide, a town is also required to adopt a second resolution within a specific time period, but no later than the effective date of that second resolution, the town has to enact its zoning ordinance, and that zoning ordinance has to comply with the provisions set forth in WSStat section 60.62. The town must adopt a comprehensive plan meeting the requirements of section 66.1001. And the town has to adopt its official map under section 62.23 sub 6. Now, these are, obviously they're important safeguards, but one other thing I want to emphasize is that whatever the town adopts has to meet the legal requirements in these statutory sections. That's key. And again, key point, the town must adopt its zoning ordinance, its comp plan, and its official map that complies with all of these statutory sections in order for its withdrawal from county zoning to be effective. And that is really, if you take one thing away from today, this is the most important point.
Well, and here's another point on this along these lines is that, well, what happens if a town's, what if their comp plan doesn't satisfy the requirements of 66.1001? Who enforces that? Can the county say no?
That's a great question.
Yeah, I'm asking a question. It's a trick question for you because there is no enforcement mechanism contained within the statute. So how in the world are we supposed to enforce the requirements that are in there related to town withdrawal? Are we simply, as a county, going to say we don't recognize your withdrawal as being valid? Can we do that? Do we have the authority to do that?
Well, those are it's a phenomenal question. And I kind of feel like it's becoming the big pink elephant in the room that we need to talk about because it's such a glaring question, but the statutes do not address it. And Act 264 did not change certain provisions in the statute that require county approval if a town is exercising village powers. So where does that leave us? I think a county could say, hey, look, town, it is statutorily required that your ordinance must comply with 60.62. Here are the sections that it doesn't comply. Your comp plan must comply with 66.1001. You know what, town? It doesn't comply based on these sections. And your official map, maybe it's affected, or maybe it complies, maybe it doesn't. And what a county can do is try to work with the town to point out the areas that these safeguards that the town has developed are defective. And again, it's placing an onus on the county that isn't in the statute. But given that goal of zoning and orderly land use, that is something the county may want to do. Step up and offer its services and expertise, really, in ensuring that the town documents meet these statutory requirements. And we're going to talk later about what county, duties and obligations are, in this process. Again, hoping that we never get to the process if we can foster communication and positive relations between counties and towns. But if we get there, what is a county's role? And I think one thing a county can do is assist a town in making sure that these three safeguard documents comply. If a town continues to move forward and thinks that they comply, maybe doesn't listen to county feedback, if the county discovers something that is not compliant with the statutes, certainly always engage in discussions with the town, again, with the goal being orderly land use, so citizens are protected and, for our best interest of the community. Whether there are litigation options at that point, there may be, but I think that is perhaps a discussion for a later day. And maybe that is something that will be worked out in future legislation.
Well, and I mean, that's the interesting point, because the what ifs are interesting at this point, but it's still so new and difficult to try to work through. Have a conversation with the corporation counsel, because your corporation counsel is your legal advisor. And so it's their interpretation about the different options that is going to be important. We're happy to help your corporation counsel with that analysis, but I think it's something we're going to have to work through in the coming years, some of those what ifs. So before we do that, we have another question here from Frederick. If a county does a comprehensive zoning code revision and a town does not opt into the new zoning code, what, if any, zoning code does the town have to have or can have? Thoughts on that, Rebecca?
Yeah, if
So
it doesn't,
they don't opt in a comprehensive revision. And if they didn't opt in and they were under the old ordinance, that means they've got no zoning now.
that's right. And they can do that if that's what they so choose.
Yeah, and then there are unzoned towns within the state of Wisconsin, and so it becomes an unzoned town. Vincent asked a great question. What incentive does a county have with making sure a town's in compliance when they're attempting to withdraw from county zoning? Ding, 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 that's right. Why should we help somebody withdraw? Why should we do that as counties? That's a great question. And I guess it comes down to this, is would you rather have a seat at the table and be part of the discussion, or would you rather have it just hoisted upon you and say, do with it what you want, we're going to fight you every inch? And it's tough, and I'm not suggesting that counties have to immediately give up all of their leverage, so to speak. But I think Rebecca's point is very, very important. And that is, how do we try to foster a cooperative relationship so that at least we have a say in what's going on at the town level? Because if we paint somebody into a corner, they're just going to lash out and fight. And I don't know that that's the right answer. But yeah, it's tough, Vincent. What incentive do we have? We really don't have an incentive, because they're looking to opt out. That's a great point.
Yeah, and can I jump in on that point too, Andy?
Yep, go for it.
All of the audience, if you have Mr. or Mrs. property owner who wants to do a rezone, who are they going to call? Chances are they're going to call the county zoning office, not the town. And you can direct them to the town opts out. But I think, one of the incentives, again, is to, foster communication, certainly, but then also continue fostering orderly land use planning. this is where I can sometimes get a little snarky and have to stop myself. But what I see oftentimes is, you can let them go and the town can take the phone calls. And if that does happen, that might not be what's best for orderly land use all the time. But the beauty of Act 264 is that if a town does opt out, the county has no obligation to take those phone calls anymore. And if a town opts out and now has to administer zoning, but they don't have the resources to do so, say they don't have the resources to have a professional planner or someone of the caliber who works in the county zoning offices, who went to school to be professional planners and have the expertise to administer a zoning code, well, maybe the town needs the county to do that. Well, then maybe the town has to pay the county to do that. We talk about Waukesha County. I believe that's the case in Waukesha County. Towns actually pay county planners to do their town planning. So that, again, looking way ahead down the road, those are some potential benefits for counties. Should a town choose to opt out and in still, fostering that communications, but maybe there will be some benefits for counties. That's just again, looking way ahead and trying to look at the glasses half full, that there may be some benefits for counties if towns do opt out.
So let's talk a little bit about some of the special issues. That's why we're here today, is to talk about some of these special issues under Act 264. Apologize, I made a typo on this slide, 2 number ones, but that's okay. So what's not included in a town's opt-out? Okay, there are 4 different categories that we've looked at as it relates to how Act 264 and the opt-out process is going to impact different areas of land use regulation that stay at the county level. Okay, and this is where it can get a little bit confusing. We've got the carve out for quarry operations. All right, that's defined within Chapter 66 as it relates to how quarries are going to be regulated. That stays with the county. Land division decisions, that stays with the county. Land that's subject to a cooperative plan among several jurisdictions or 2 or more jurisdictions, that's going to stay with that cooperative plan. And then the farmland preservation program, that's going to stay with the county, or at least there's going to be county input as it relates to implementation of that farmland preservation plan. So let's start with quarry operations. And okay.
Oh, whoops.
No, go ahead,
I
Rebecca.
did this one. This one is an error on my fault, or the error on my part. This is what we wanted to talk about in terms of an opt-out. It doesn't
Oh,
get
all right, go ahead.
towns out of. Not, so this one, we don't get to quarry operations yet. This one is
We
just
don't yet.
kind of
This
general.
talks about shoreland CSMs and floodplain zoning. So you want to talk about that?
Sure. So let's say a town does opt out, it adopts its 3 safeguard items, checks those boxes. It is officially out of county zoning. What's not included of that? County shoreline zoning. This is a significant one. The county does not lose approval or objecting authorities over the CSMs in the shoreline zoning areas. The county maintains its jurisdiction of shoreland and floodplain zoning. I think that this was absolutely the right decision from the legislative standpoint, because the county is given exclusive jurisdiction and responsibility to implement the state standards for shoreland and floodland zoning. So those stay with the county.
Here's one of the things, and let me just interrupt, sorry, Rebecca, real quick. And this is where we see these issues regardless of whether we have opt-out or we have town zoning, is that counties have exclusive jurisdiction within the shoreland zone. So counties adopt shoreland zoning regulations. Here's the rub, is that I know there are several counties out there that do not separate their general code from their shoreland code, or they incorporate by reference certain elements of their general code or their entire general code into the shoreland code. Technically speaking, if you look at 59.692, a shoreland zoning ordinance is established to regulate shoreland zoning standards that are contained within Chapter 92 and NR 115. And so the question becomes, is a particular county regulation, is it a shoreland zoning standard or a shoreland zoning issue that belongs in the shoreland code, or is it just a general provision that's found its way into the shoreland code? And so I think we're going to see over the years probably some good back and forth between town and county as to whether a particular county regulation applies in a shoreland code. Again, this issue exists regardless of Act 264, but with a town's withdrawal, there might be misconception about what particular provisions are going to continue to apply within a town that has taken itself out of county zoning pursuant to Act 264. I think those issues are going to continue.
You know, and the other, keep in mind too, folks, that if a county wants to amend its shoreline zoning and has the authority to do so under the statutes, if a town has not opted out, a county does not need that 50% threshold of town approval for changes to its shoreline zoning ordinance. And so that dynamic, I think, comes into play when we're talking about Act 264 too. So we already see this sort of philosophical removal of shoreline zoning, you know, from town's purview. And that continues through, you know, under Act 264.
Before we move on, let me, Frederick asked another good question. What's the process if a town doesn't opt in, if we have a comprehensive revision to our county code or county zoning ordinance, a town doesn't opt in, then what can it do if it wants to administer its own zoning code? It has to adopt village powers. There's a process for doing that. It has to adopt its own zoning ordinance. Then the county board has to approve that ordinance in order for it to be effective within the town. So that's a separate process. We're not going to get into details with that today, but just it's a separate process out there. So then if we look at the other elements, it doesn't extend to stormwater management regulation, erosion control, or the personal on-site wastewater treatment system, septic system permitting, all right? So again, when we talk about quarry operations, this was a particular issue that arose in the context of the quarry operators, I think, as a group, as a conglomerate, if you will. They are concerned about disparate regulations depending upon which town they're in within the same county, disparate regulations across the state, and they would rather have uniform regulations imposed upon their operation. I get that. It sounds really good. But again, that runs directly contrary to our desire as Wisconsinites to have local government at the local level controlling land use decisions. And so we always have consistent conversations with quarry operators and their associations about the need for continuity versus the need for local control. And as counties, as towns, we're always all about local control on these land use decisions. And so we had this special provision that the quarry operators insisted be in this Act 264 opt-out. They said that if a town withdraws from coverage by a county zoning ordinance, all right, and adopts its own plans and everything, that town ordinance, that town plan does not regulate quarry operations as defined in 66.0441. What are quarry operations? The extraction and processing of minerals at a quarry and all related activities, not just the extraction of minerals, all related activities, including blasting, vehicle and equipment access to the quarry, loading and hauling of material to and from a quarry. Why do I bring all of this up? Is that there are elements of a quarry operation that towns can regulate, no doubt about it. Act 264 doesn't change that. But there are also elements that a town cannot regulate under Act 264. And so we have to be careful because I don't care how well you draft the statutory language, there's always going to be a dispute about what is or is not a quarry operation. That is another one of these issues that we're going to have to pay attention to as we mature with Act 264.
And on that, Andy, if I can just point out too on that point, even though you know, a town may not have authority to regulate those quarry operations if it opts out, you know, there's nothing to say that a town won't still try to. And so counties may see situations where a town has opted out of county zoning, but still adopts regulations addressing quarry operations. And if that situation occurs, at least a county will have a statute, the statute to cite to say, hey, no, sorry, town, you adopted an ordinance, but it is not legally effective because you don't have jurisdiction to regulate these quarry operations. So a good thing for counties because we actually have something that we can point to that will, you know, establish what, or clearly establish that towns don't have jurisdiction to regulate and counties do.
Well, yeah, and it was actually back in the mid to late 2000s when we had the Zwiefelhofer versus Town of Cooks Valley case. It was a non-metallic mine, and the town adopted a licensing ordinance. And the argument on the quarry operator side was that is really a zoning ordinance dressed up as a licensing ordinance. Towns don't have the authority to regulate in this fashion. That argument didn't prevail. The Supreme Court recognized the town's ability to adopt licensing regulations. And so you've seen a constant push from quarry operators over the last 15 to 20 years to say, no, we don't like that decision. And so we think that zoning is actually zoning, not zoning kind of like licensing, kind of not like zoning. So quarry operators are, again, looking for that continuity in terms of regulatory authority.
And the same on that point, Andy, with licensing for renewable energy siting. We're seeing those across the state where towns are adopting what they're calling licensing requirements that towns will argue don't fall under zoning jurisdiction and fall outside of state preemption. And that's really, that's a town issue. It becomes a county issue when we're trying to, enforce our own zoning codes, but same trend. And simply because a town calls it a license doesn't mean it's a license. Like, if it looks like a duck, if it walks like a duck, that's kind of the approach that the court used in Zwiefelhofer. So
No,
not
and Kurt brings
good.
up a good point. Kurt brings up a good point. He asks, okay, does this just apply to existing quarry operations or new ones after the town leaves? Great question, Kurt, and it brings up this concept of legal non-conforming use. We can't make what's legal today illegal tomorrow. Somebody has a right to use their property within the boundaries of what's considered the law on legal non-conforming use. They have the right to use that property as they have in the past. And so when we talk about quarry operations, it would apply if a town withdraws, it would apply to existing and future quarry operations. It's anything having to do with quarry operations under Act 264, the town does not have regulatory authority from a zoning perspective over that quarry. So we're approaching time issues here, Rebecca. Hard to believe.
No, and we're finally
Discussion
into the
so
meat
far.
of what it is we're going to talk about. Some of these.
Yeah, so land division. Let's talk about land division because then we get to the carve outs as it relates to shoreland floodplain. So talk to us about land division.
Okay, so land division authority was rolled into Act 264. So we always talk about towns withdrawing from county zoning authority. And we should really say that towns can also withdraw from county overview of land divisions, because this is a very important part of Act 264, which often goes undiscussed. And so if a town follows its steps, does the 3 safeguards, withdraws from county zoning under Act 264, upon that town withdrawal, a county no longer has objecting or approval authority of either a preliminary or a final subdivision plat. And that is a significant difference than the law now. There are lots of concerns that we've heard because oftentimes the preliminary or final subdivision plats will contain important elements such as shoreline regulations. And are we entrusting now towns to approve land divisions that have to or should memorialize elements of county zoning? And so that's really the fundamental concern about not having the county having that approval or objecting authority. So if a town does withdraw from county zoning, that impacts any preliminary plats or final plats submitted for approval after that's withdrawal. It does not apply to preliminary or final plats that are submitted in that 5-year window or in that time frame of planning. It's only effective after the date of withdrawal. Now, exception to this is the county maintains objecting authority for the preliminary and final plats if any portion of that subdivision is in the shoreland or in the 100-year floodplain. And so this is key for 2 reasons. Number one, the counties are not reviewing or approving authorities. It's an objecting authority. And under the statutes, those 2 are different. And so this is the county's opportunity to still stay involved if any portion of that preliminary or final plat has shoreland or floodplain in it. But again, changes the way counties do business. So certified survey maps, obviously also a land division under Chapter 236, same rule generally applies. If a town withdraws, a county no longer has approval or objecting authority over a CSM that divides the land that is located in the town. So time frame is also the same. The town must have its final withdrawal, and then moving forward, CSMs are not subject to county approval or objecting authority. But if that CSM contains shoreland or floodplain, then the county does have objecting authority. It doesn't have approval authority, but it has objecting authority. So again, that's one of our safeguards. So let's talk about objecting authority a little bit. What the heck does that mean? So if you have a preliminary or final plat, the DOA must provide a copy of the final plat to the county as an objecting authority. If your county has a full-time planner or other person responsible for implementing planning legislation, which I think is a really kind of interesting description in the statutes. You know, we don't know what the standard is for person responsible for implementing planning legislation, but county has one of those. And the county has adopted a policy of requiring submissions so the county can determine if it has any objections. So this point is key, folks. If you've got towns who do withdraw from county zoning, make sure you have a policy in place to establish that the county wants to have that objecting authority, because you need both of those items. You need that planner or person responsible, and you need that policy requiring submission. So those are very important. Extraterritorial plat review. This came up in a presentation I did last week, and I was asked a question about extraterritorial plat review and what the impacts of Act 264 are, if any, on extraterritorial plat review. And this is something I had never been asked this before. And Andy, I don't know if you had ever been asked this before.
No, I hadn't.
So brand new issue. We've been talking about Act 264 for over a year, and this is a new question. So again, extraterritorial plat review and frankly, extraterritorial zoning allows a municipality to take steps in order to review plats or have an input in extraterritorial zoning under the statutes. The intention being, if a town or if a city or village is going to expand and absorb that town, it wants to have a say in the planning process. That's kind of the fundamental premise of extraterritorial authority. In Act 264, we're talking about that independence of the town and the town's authority. But Act 264 did not amend the extraterritorial plat or zoning provisions. So the takeaway is Act 264 did not change that municipal authority over town independence, if you will, which I think is so interesting because again, the goal of Act 264 from the town standpoint was to have additional independence. But Act 264 did not change any municipal authority in that extraterritorial realm. So very interesting. Cooperative plans and boundary changes. Some of you may have towns and municipalities that have these cooperative plans or boundary agreements, so those municipalities don't suck up all the towns. If there is one in place, a town withdrawal under Act 264 does not change that boundary agreement until its withdrawal, the town's withdrawal becomes effective. And what's interesting is that there's language in the statute that almost reads like a cooperative plan or boundary agreement may supersede certain rights that a town has upon withdrawing from county zoning. So this is an issue I think we're going to have to be talking about more, because if we've got a cooperative plan or boundary agreement that is not consistent with what a town may do if it opts out of county zoning, and there's that conflict, which one prevails? And right now, we don't know. So again, I think that's going to be an issue we see down the road.
So real quick, let me just touch on a couple of questions that have come up. Allison asks about when we talk about CSM and plat review, is that applicable in counties that have adopted the subdivision ordinance under 23645?
Yes. Yep. Even so, if a county has a subdivision ordinance, that subdivision ordinance is no longer effective if a
Right.
town opts out.
Right, so if there, but our objecting authority as counties continues, that wasn't modified.
If there is shoreland or floodplain in that land division.
That's right. Kurt asked about the process that a county would utilize to review a town's submission of its ordinance to the county board for approval. All I'm going to say on that, Kurt, is that it's a legislative decision on the part of the county board. We want to document that legislative decision, make sure it's based upon fact. And once we document that decision, a court reviewing that is going to just find out if the county followed a process that is consistent with law. And what I mean by that, it's a certiorari review standard at that point. And so I think that the county, if it has concerns about a town zoning code, can certainly express those concerns. And if it decides not to approve, it doesn't approve. So I think we're okay. All right. Farmland preservation. Do you want to talk about farmland preservation,
Yeah.
Rebecca?
So farmland preservation, we included an overview here of some of the general goals. And these are important because, you know, when we talk about the farmland preservation program, that can result in significant tax savings to owners if they follow certain steps. Making sure that those boxes are checked has traditionally fallen on a county. And so when we're looking at that goal of preserving agricultural history and the economic benefits of, you know, prime agricultural farmland, that's an important concept that's really baked into not only our laws, but our culture. And so how does Act 264 and its removal or potential removal of towns under that county zoning umbrella affect this program, which is really, for all intents and purposes, separate? So when we're looking at farmland preservation programs, the requirements are set forth in chapter 91 of the statutes. We have to have a farmland preservation plan. There has to be certain farmland preservation agreements. There must be a farmland preservation zoning that is certified by DATCP, which is the state agency with regulatory authority and oversight authority. And then we also have to have agricultural enterprise areas as an option for involvement within that farmland preservation program. Andy, I don't know if you want to flip ahead. These are just you know, some more details that we wanted to include. This is the important part. So what happens upon a town's withdrawal from county zoning? Well, the town's safeguard documents, those 3 documents, have to be sufficient enough to check the boxes in the farmland preservation statutes. And so the concern is that making sure towns understand what is needed in order for those citizens to continue to receive their property tax credit. Now, this one is interesting because a county's obligation to have a farmland preservation plan under Chapter 91 does not change. So if in your county you have no towns that fall under county zoning, you still have to comply with that element of Chapter 91. So that does not go away.
So from an enforcement perspective, am I reading this, thinking about this correctly under Act 264? Town withdraws, town wants to make sure that it continues with its farmland preservation program. It's on the town to make sure that it checks all the DAT boxes on the requirements for that program. And really, it's up to the private landowner to make sure the town does its job, because the private landowner loses out on a ton of financial benefit if the town doesn't follow the right steps. Is that right?
That's right. That's right. One of the other concerns too was that the county has to provide certain certifications. And within that withdrawal process, those certifications have to follow a specific timeline. So a county may face a situation where it's being asked to certify an ordinance or certify an element of that farmland preservation program that is now becoming subject to a town zoning ordinance. That may cause some rub. And so again, the timelines of the farmland preservation program and when those boxes have to be checked are very particular. And so again, communication, coordination is key.
I want to briefly touch on this whole issue with renewable energy. We see the whole concept of solar farms proliferate across the state. We've seen that the last few years, and we've seen a strong desire on the part of towns in some counties to say we want to regulate the installation of these renewable systems. Understand that the legislature has already acted to withdraw from county and town regulatory authority oversight responsibility on those renewable energy systems. We have entire discussions on the regulation of renewable systems in the boardrooms, wicounties.org, if you want to see those discussions. We simply wanted to point out that Act 264 has nothing to do with that. So if a town thinks that they're going to opt out of county zoning and start regulating the heck out of these renewable systems, they've got another thing coming. They don't have any sort of enhanced authority. Their authority is not diminished, but they don't have any sort of enhanced regulatory authority over those renewable systems. We just want to make that point clear. So we're at the point of questions, and I know that we're at 101. So let me just ask a couple of questions here, Rebecca, and we can maybe discuss these things. Susan asks, okay, independent of Act 264, if we have a land division process within our county, if a town opts out of county zoning through the traditional process or never opts in on a traditional process, does the county have regulatory authority under 236 to approve land division?
Yes. Yes, because I think the land division statute within 236 applies regardless of an opt-in. There's not a similar process of opting into a land division ordinance as there is to a zoning ordinance. So if I'm understanding the question correctly, so if a county has a town that either has not opted into county zoning or quote unquote opts out under village powers, the county subdivision ordinance still applies to that town. And
That's right.
Town.
Vincent brings up a good point as it relates to regulation of renewables, and that is towns and frankly counties are encouraged to get joint development agreements in order. Again, we've had full discussions on regulation of renewable energy. We talked about the concept of joint development agreements. I know, Rebecca, you've been involved in negotiating many of those agreements. And it's really important that we have an understanding at the county level and the town level about what we can insist on being in that joint development agreement. I will tell you right now that we have leverage. We still continue to have leverage to get what we need in that joint development agreement. The state may have taken away our regulatory authority on zoning, licensing, and so on, but it did not take away our power to contract with a developer to make sure that a project proceeds as we would like to see it proceed. So I think that's a continuing discussion about what these joint development agreements look like. Frankly, it's a continuing discussion because we don't know what's going to happen at the federal level with the tax incentives that really incentivized a lot of these renewable projects to get off the ground. So it's going to be an evolving process over the next few years to see what the future holds. But yes, please have conversations about these joint development agreements and what they look like. And if you have questions, feel free to reach out to us. I know, Rebecca, you've been all over the state having discussions with county boards about joint development agreements and regulation of renewables in particular.
Yep. Yeah. And the trend that we're seeing at PSC, that approvals are for renewable energy facilities are going through very quickly. And so it has the feeling of with these, quick removals, where does a county's voice come into play and how can a county get a seat at the table, and the JDA is the best mechanism to do that.
All right, I don't see any other questions either in the chat or the Q&A. I'll just remind folks that the next session of In the Boardroom is going to be on April 23rd, where we're going to talk about county support for nonprofit organizations, that 2017 Attorney General opinion, and forward the latest and greatest analysis on that. Like I said at the beginning, if you have questions about any of the topics we've discussed today, feel free to reach out to us. Our contact information is on the screen. This particular discussion, along with the slide deck that we utilized, is going to be available at wicounties.org. So feel free to download it from there. But otherwise, thank you very much for your dedication to county government interests and your interest in this topic. This stuff isn't easy, and we are always happy to continue the discussion on these important issues. Rebecca, anything you want to say to close out?
No, just to echo the thank you to each and every one of you on this presentation. You know, these are very challenging issues, and I work with a whole lot of planning departments across the state, and our counties are very, very lucky to have the types of professionals that we do. And so thank you to all of you for working through a lot of these very challenging issues.
All right, and with that, we will conclude our discussion for In the Boardroom for today, and look forward to seeing you all again next month. Take care.
Bye, everyone.